This is a new sort of platform for many of us. Of course, some of us have used Webex before. We're accustomed to that platform. However, for court reporters, typically, if we do teleconference, we call the bridge line. So, but it looks like you guys have mastered that, got on, and had no problems with that. So, I don't suspect we'll have any hitches along the way. It'll just be like a regular teleconference, except for we're on the computer. That's the only difference.
We have one more call-in user. Who just joined us by phone?
Hey, it's Toby.
Hey, Toby.
Welcome, Toby. You're just in time. We were just kind of getting the preliminaries going. Okay, so we'll call this meeting to order. It is now 2:04. For the sake of the roll call, just to establish quorum, I'll go run down the list right quick. Britton Collins. Judge John Rambo.
Present.
Marilyn Morgan.
Here.
Ken Mansfield.
Present.
Brandon Pettis.
Present.
Orian Neal.
Present.
And Stephanie Branham.
Present.
Great. We do have quorum. Let me read the statement of necessity. As you know, with any other teleconference or any electronic recording, we have to enter a statement of necessity and file that with the Secretary of State's office. So let me go ahead and read that to you. It is as follows. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body. That physical presence by a quorum of the members is not practical within could
This is Ken Mansfield. I make the motion to be adopted.
Toby is our commissioner over a regulatory board. And
obviously we know about this pandemic that we're all facing, and it's challenging in our own ways. The governor obviously has been doing press briefings at 3 o'clock, and usually in the lead up to that, the department is heavily involved with some of the initial pieces in the shutdown, and obviously now kind of coming back out of that and rising up with some of the reopen plans for our different professionally licensed industries. The department was very quick to respond in kind of mid-March. We, as you probably know, have a very sophisticated work from home model where traditionally we had been working out of the office 3 days and in the office 2 days. So moving to work from home, to a work from home position for everybody 5 days a week has actually gone fairly seamlessly for our department. Commerce Insurance was pretty much ahead of the curve in adopting that model over the last couple, 3 years. And so we've seen very little downturn in servicing our customers and the community. Frankly, the only thing that where we're lacking there is the services that we may have provided someone who actually physically walked into our building. So we're servicing things well. Our metrics are largely holding up well. We do see a downturn in certain initial new license applications. I think that's probably to be expected for where we are and the environment of things, but we'll be watching those numbers. We've had no problems with this particular program of court reporters, but I'll say that Glenn and Roxana and the staff have been very responsive, not only to this program, but to the other programs for Umbrella. Also, to give kudos out to our legal team, they've done a fantastic job being responsive across the board, continuing to supply really good advice and making sure that that we're all on the same page. I think in the days and weeks ahead, you're going to see a lot of the stories move away from the virus itself and more to the economic recovery. Although I know that the command team and the governor's office are very committed to tracking and maintaining a handle on the health of the state, and those decisions will then work with the economic recovery group as we work on the economic conditions of the state. We'll be out of the office until probably the end of May. I think we're targeting May 29th as our return to work. We thought initially that would be next week on May 4th, but that got extended out. So we will continue our work from home model at this time. So use all the different channels to contact the department and Glenn and the team where necessary between now and then. But even after that particular point in time, I think we will be very careful and cautious how we reopen the department and how we re-inhabit our spaces. Just as we want to make sure that our employees and staff are cared for and their safety is paramount. And if everyone gets sick, we can't serve the public. So we're being very cognizant of that at this time. That's really, in a nutshell, kind of what I've got. I've been deeply involved with the Economic Recovery Group and building plans to kind of, as we move forward. And our commissioner, Haji Manda, has done a fantastic job of keeping us informed and being there with the governor and his team and helping kind of guide us through this kind of strange and eventful situation. So I'll leave it there. I just wanted to say hello on this beautiful, at least here in Nashville, beautiful Monday afternoon, and see if there's any questions. Turn it over to you guys.
All right. Thank you, Toby. I appreciate your comments and getting us caught up. And just to pile on there, I just want to say we all in regulatory boards appreciate our executive management, their leadership in this difficult time, and just the governor's office as well. We've had all the support we've needed and wisely navigating and striking the right balance, in regards to our duty and also public safety and the safety of the employees. And we all appreciate that. So thank you for doing that and for addressing the board.
You're very kind, Glenn. Anybody have any questions or thoughts or concerns for me?
All right.
No news is good news.
We'll take it then. Okay. Thank you. We'll move on then. And I imagine, of course, if there's anything on the way that you'd like to address, feel free to interject as well. Roxana is she's on the line as well. She's going to be listening in, and in case I forget something or if there's something that additionally that needs to be addressed, then she'll be available as well. I just want to let the board know that. Roxana, did you have any comments?
Thank you, Glenn. I don't think so. I think Toby did an outstanding job recapping where we are during these difficult situations. Thanking you all again for participating telephonically and jumping in. And as you know, Glenn is fantastic with this program. We did do email communications to all licensees. We did that a few weeks ago, just letting them know of the status, the fact that we were working from home. So hopefully many, if not all of you, received those. And we'll probably do some more communications here in the near future. But I think Toby covered everything, and I'll turn it over to you, Glenn, if we've got questions in the end for me as well. I'm going to be on here the whole time. So thank you.
Thank you, ma'am. All right, one last introduction, and that's the board. I just want to let you guys know that we do have a new attorney. Hugh will be joining us today. So if you hear a different voice, it doesn't sound like Ashley. That would be why. Hugh Cross is with us today. Ashley was recently promoted. She's a supervisor now, and she'll be, so she's still within commerce and insurance. She hasn't moved on from the state. We still have access to her resources and her experience with the Court Reporters Board. She's been with the Court Reporters Board for a while. You guys, of course, are very familiar with Ashley. So she's nearby, but Hugh Cross is also a very experienced attorney. Really likes getting his hand in the dough. We've seen that already at Cosmo and Barber. He's been a real asset to regulatory boards, and so we suspect that that will continue on. If the past experience is any demonstration of what to expect, then we're in good hands. So Hugh Cross will be joining us today and handling that portion when we get to the legal report. Dennis Gregory, of course, our disciplinary action attorney, he's still with us, so you'll recognize his voice as well. But so that was our last introduction. Hugh, did you have any comments that you'd like to make?
No, other than I really appreciate the introduction there. I hope I'm not that experienced. I graduated law school from University of Michigan last year, so I still feel like a baby in all of this, but I hope that I am an asset to this board, and I'm glad to be here. So please let me know if you have any questions.
Oh, thank you, Hugh. Appreciate you. Okay. Well, all right. Ladies and gentlemen, we're ready for the next portion of the agenda, which is the agenda. So if you could take a look at that agenda with me and let me know if that comports with your understanding of what was going to transpire today, or if you had anything you'd like to move around or add, this would be the time to do that. If not, we'll entertain a motion to accept the agenda as printed and written.
This is Ken Mansfield. I move that we accept the agenda as printed.
Thank you, Mr. Mansfield. We have a motion. Do we have a second?
This is Brandon Pettis, and I second that motion.
Thank you, sir. We have a second from Mr. Pettis for roll call vote. Judge Rambo?
Yes.
Thank you, sir. Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Pettis?
Yes.
Ms. Neal?
Yes.
Ms. Branham?
Yes.
All right, thank you all. The agenda is passed in as written. Of course, we have an opportunity in new business if we needed to add something there. September minutes. Of course, everyone was able to receive those documents already. Is there any comments on the minutes, any any edits, or anything that needs to be added? This would be the time to make those comments. Okay, we'll entertain a motion to accept the September minutes. Do we have such a motion?
This is Marilyn Morgan. I make the motion to accept the September minutes.
All right, thank you, Ms. Morgan. We have a motion from Ms. Morgan. Do we have a second?
This is Ken Mansfield. I'll second that motion.
All right. Thank you, Mr. Mansfield. You are a second then for a roll call vote. Judge Rambo?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Pettis?
Yes.
Ms. Neal?
Yes.
Ms. Branham?
Yes.
All right, thank you. September minutes have passed. We'll put that into the record and have those posted onto the website here shortly. You're probably wondering now, why do we have March 2019 minutes? There was, we had one individual, Miss Wilson, if you recall, for some time ago. She addressed the board, and in the minutes, we indicated that she was a representative of Tennessee Court Reporters Association. We just need to strike that from the record. She was not an official representative of Tennessee Court Reporters Association, although a member. She was not representing them at the time that she made her comment. So we're just going to strike that from the record. And if you recall, that was at the time when we were discussing the two rule edits. It was a while back. I mean, we're talking last year. So if you can remember that far ago, I can't remember last week, but if you can remember that far ago, we were discussing those two rule edits, which will have a rulemaking hearing in September. And we'll unpack that again. But that discussion, she was one of the individuals who addressed the board. So we'll just strike that she was a representative of Tennessee Court Reporters Association. If that's fine with the board, we just need a motion in that regard since it is an edit.
This is Marilyn Morgan. I make the motion to accept the edit.
Okay, thank you, Ms. Morgan. Do we have a second?
Stephanie Branham, a second.
Thank you, Ms. Branham. All right. A roll call vote. Judge Rambo?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield,
Yes.
Mr. Pettis,
Yes.
Ms. Neal,
Yes.
Ms. Branham.
Yes.
Okay, great. We'll make that edit then, and then that will be adjusted on the website as well. Okay, moving along, we're at the director's report. Let's go to the budget. This will be brief. As you all know, unless we're in a renewal period, we typically run in the red. This is no different. You'll see that if you're looking at the budget now. I looked at all the lines and didn't see anything that looked outside of the ordinary. It looks like we're running, let's see. We're tracking a little over 6,000 in the red, which, really isn't that terrible given the fact that we're not in the middle of a renewal period, at least up until now. We are now, we're coming upon one, but up until this point, for us to be only running in the red, $6,000, that's pretty good. Our end year fiscal reserve balance so far is a surplus of 125,000, and of course we'll see more than that over and above once we enter in this renewal period and start receiving the revenue that will be generated from that. So right now the budget is healthy, and it's tracking where it needs to track. Is there any questions concerning the budget? This is just for informational purposes. There's nothing really to discuss or to vote on other than that. There wasn't anything outside the ordinary, but if there's something that you see in there that you would like to ask a question on, this would be an opportunity for that if something jumps out at you. Okay, well, we'll move on then to a renewal cycle update. All right, we have 482 active reporters who will need to renew this year since we are in a renewal cycle. That will be 2 months from now. That'll have to be done by June 30th. We will send out email notices in that regard on Monday. We waited on those initially a couple weeks. We typically will send out the mail notices. We waited on that because things were happening so fast. Things were changing so fast with COVID. We didn't want to get into a renewal period where an executive order might be affecting that. Now, we did have a recent executive order 15, and that will in fact affect 14 reporters. There's only 14 that will be impacted and that will be affected by executive order 15. Those were the 14 that I'm referring to are those that were licensed around the 1 year mark or less prior to this renewal period. An additional fee and CE requirement so soon after being licensed was determined to be particularly burdensome in this current COVID-19 climate. And with the authority granted to us by Executive Order 15, it was determined to waive that requirement, at least the additional fee in the CE. However, the situation did highlight an opportunity to clean up one of our statutes. We have requested that administration and Toby agreed that this would be a good venture to at least consider, but to carry a departmental bill that requests a change on TCA 20-9-611. I don't know that it'll go, as it has to go through many stages along the pipeline. So we'll see if it gets carried, but it is at least the will of administration and right now to at least put this up for consideration. Let me just read it to you. It goes like this. The fees for licensure pursuant to this part shall be established by the board and shall cover a 2-year period from the date of issuance or renewal of the license. Okay, so nothing new there. All licenses shall expire June 30th in the year of expiration, and all renewals be effective July 1. Okay, nothing new there either. However, and this is the part where we want to clue, or at least drill down and target. Provided, however, an initial license not issued on July 1 shall be valid from the date of issuance until June 30th of the second year from the June 30 preceding the date of issuance. The board shall impose a prorated fee for any license that is for a period less than 24 months. So basically they're saying if someone was first licensed, less than 24 months, they would apply a prorated fee. Problem with that is that prorating is not possible within our current platform, and the CE requirement is not addressed in this outdated statute, and that was carried over from the Administrative Office of the Courts. So it would be of assistance if this could rather state that at the time of renewal, if the initial license was less than a year, then the CE requirement would be waived and the renewal fee reduced in half. So just sort of, you're outside, if you were first licensed with outside of the 1 year before your next renewal, then this wouldn't apply to you. However, like these 14, if you were licensed within a year, first license within a year, you know, what you don't want is somebody that was just licensed 5-6 months ago, and they're automatically having to pay another a renewal fee, another $200 right after just being first licensed, and then having to drum up the CE as well. Now in the past, that was just the disadvantage of being first licensed so soon before syncing up with the renewal period. So, but that's a cleanup that's really well overdue. So we'd like to touch this outdated statute and get this one cleaned up. We hope that this one will get carried and will be taken care of by the time we get to our next renewal period. But at least given the executive order and the climate we're in with COVID-19, I think we can at least give some relief to these 14 reporters. But you know, we don't want to just do a workaround when we need to fix fundamentally fix the problem. So we're focusing on that, and that's what we're going to work on at least hopefully in the next months ahead in the next legislative session. Is there any comments or questions about that? Okay. That's all I had for the renewal cycle update. Let's see. I guess we'll move to the fun stuff, the election of officers. As you know, let me just read the statute that drives us here at our first meeting of every year. It's TCA 29604F. It states this: at its first meeting each calendar year, the board shall elect a chair, vice chair, and secretary from its membership. No member shall be elected to serve more than 2 consecutive years in the same office. Right now we don't have a chair. We do have a vice chair. Miss Morgan is currently serving in that, and our secretary is Judge Rambo. Miss Morgan, have you served 2 years as vice chair?
I think so.
Okay. So then you would be eligible to serve in another position, but not as vice chair. So we'll need somebody to make a motion for vice chair. And I would say if we can to keep this real clean, if someone would make a motion for chair, vice chair, and secretary. Judge Rambo, have you served as secretary 2 years in a row?
I think this is my first year, but I'm not sure.
I think it was too. I remember having this discussion this time last year, and I think you were maybe a vice chair or and then maybe over to secretary. So I think you would be eligible for secretary again, but Miss Morgan could either serve as chair or secretary or whatever the will of the board was. But if somebody could make a motion for those 3, and then we can discuss that. Or we just let's discuss chair. Anybody have a motion for a chair?
This is Stephanie Branham. I make a motion for Marilyn Morgan to serve as chair.
Okay, great. So Miss Morgan as chair. Do we have a vice chair? Stephanie, do you have a motion for perhaps a vice chair?
I don't.
You want to put you on the spot? There's somebody else. That's fine. Anybody else? How about Judge Rambo? I don't know that it'd be the will of the board, but if you're willing to slide over as vice chair, just so we make sure we clear the 2-year hurdle, just in case you were secretary twice, would you be willing to do that?
Yes.
Okay, great. So Judge Rambo as vice chair. So do we have any volunteers for secretary? Anybody that would be willing to cover that position?
This is Morgan Neal. I would volunteer.
Great, thank you, Miss Neal. All right, Miss Neal for secretary. So just to bundle this nice and neat, can we get somebody to make a motion for Marilyn Morgan as chair, Judge Rambo as vice chair, and then Miss Corian Neal as secretary?
This is Ken Mansfield. I make a motion that the prospective officers be elected to serve.
Thank you, sir. Do we have a second?
This is Stephanie Branham. I'll second.
Great. All right, for roll call vote, Judge Rambo?
Yes.
Miss Morgan?
Yes.
Mr. Mansfield,
Yes.
Mr. Pettis,
Yes.
Ms. Neal,
Yes.
Ms. Branham.
Yes.
All right, thank you so much. We have our officers in, so we've met our statutory obligation. Thank you, members. We appreciate that. Now, if we can move to the reciprocity agreement between Texas and California. Let's have that discussion right quick. Let me see if I can open this up for you to kind of tease the discussion, sort of create the primer for and the groundwork for that. Basically, TCA 20-9-610 grants the board to enter into reciprocal agreements with other states to allow for licensing of their court reporters if that state's requirements, quote, has substantially the same or more stringent requirements. So today we're looking at Texas and California. If Texas or California are seeking to enter into a reciprocal agreement, then the question we would put to the board then is, are their requirements substantially the same or more stringent? So, and if we believe, and when I say we, the board, based on your expertise, believes that their requirements are substantially or more stringent requirement than that of Tennessee, then you would have the prerogative of drafting a reciprocal agreement between those two states. I could, before we start, if you like, I can go ahead and open up what are our requirements, and then briefly just touch on their requirements. We did have one licensed court reporter reach out to us and object but it was more non-competitive basis, which we can't make that into consideration. We have to go based strictly on the law and based on what is permitted by law. So what we'll have to do is, based on that standard, take a look. The standard of substantially the same or more stringent requirements, we'll have to evaluate California, and we'll have to evaluate Texas, and then the board will have to make that determination. So first read your California's requirements, and we've also got Texas's requirements. And well, let's start with Tennessee's. That would be the standard anyway. Okay. So what it comes down to, Rule 455-01-0302, Paragraph 1, Section A, proof of passage of the National Court Reporters Association Registered Professional Reporter Examination, the National Verbatim Reporters Association Certified Verbatim Reporter Examination, or the American Association of Electronic Reporters and Transcribers Certified Electronic Court Reporter Examination. That is the entrance to this profession. So we need to determine if those tests are substantially the same or more stringent than what Texas and California offer. If it is, and the board is willing to grant that reciprocal based on that determination, then we can begin drafting an agreement between Tennessee and those states. California, they require that each of their applicants have 1 year of experience in making verbatim records of depositions, arbitrations, hearings, or judicial related proceedings by means of written symbols or abbreviations in shorthand or machine shorthand writing and transcribing these records. They also, or a verified certificate of satisfactory completion of prescribed course of study in a recognized court reporting school, or a certificate from that school that evidences an equivalent proficiency and the ability to make a verbatim record of material dictated in accordance with regulations adopted by the board contained in Title 16 of the California Code of Regulations. They also, another requirement, a certificate from the National Court Reporters Association demonstrating proficiency in machine shorthand reporting. So any one of these qualifications. A passing grade on the California State Hearing Reporters Examination, so they have their own examination. And then another requirement, a valid certificate or certified shorthand reporter certificate or license to practice shorthand reporting issued by no states, or reciprocity. So let's just take California. If someone would like to begin that discussion, does that substantially meet or exceed our requirements?
Glenn, this is Marilyn Morgan. If I could interrupt just a second. Max Curry, the president of Ncra, is on the line with us, and he has quite a bit of knowledge about the certifications. Is he allowed to speak during this process?
Yes, ma'am. Yes, ma'am.
I think he would like to, and maybe he can enlighten us a little bit.
Okay, that sounds fine. Mr. Curry, if you want to unmute your microphone, please address the board.
You're allowing me to address the Tennessee Board of Court Reporting. As the president of the National Court Reporters Association, I would like to address the stenographic portion of the licensure law in Tennessee and address it as the president of Ncra, but also address it as a licensee of the Tennessee Board. I was also one of the members that was involved in the original writing of the Court Reporters Act that was passed. And I would like to share with you what some of this discussion that was around the A portion, that was the reciprocal agreement portion of the bill when it was still a bill before it became a law. And the whole point was to create a minimum standard of proficiency by which people enter the field of reporting and are held accountable to that minimal proficiency to be able to practice reporting in the state of Tennessee. It was never meant to be a barrier of entry. It was meant to be an establishment of a basic skill set to safeguard litigants in Tennessee and to safeguard the legal community. Secondly, you know, the reciprocity part was put in there specifically to grant reciprocity back to other states and for them to grant reciprocity to us. And many states do that on a regular basis, recognizing the Tennessee license is based on the National Association's RPR, Registered Professional Reporter proficiency, as far as the stenographic means of licensing. And it is well known in the court reporting community nationwide, especially amongst leadership, that the Texas test and the California test far exceed the RPR standards that are required through the National Court Reporters Association. Specifically, they are the only two remaining states. Actually, Texas has just remedied this recently because of the shortage issue of reporters. But up until the last year, Texas and California were the only ones that did not grant reciprocity based on the passage of the RPR because their tests were deemed as being superior to the RPR. The Texas test is a very difficult test to pass. Their pass rate is much less than the national rate for the RPR. And the California test, being 20 minutes at 4 voice at 200 words a minute, is an extremely difficult test to pass, even for a minimally experienced reporter. I think anybody on this board that's a licensed reporter would be able to pass it. I would be able to pass it after 30 plus years of experience, but a novice reporter coming out of school would be challenging. And so both of those tests have been deemed nationwide by the entire leadership of the court reporting industry as being superior tests. And Texas just recently, because of the shortage issues, has granted a caveat to their licensing that they will accept the RPR with 3 years of experience, but also the caveat of passage of their written test, the Texas written test, so that you understand Texas law. And so I wanted to explain that to give some background about how the law was developed and what the discussions were around Section A of the Court Reporters Act that deals with reciprocity when the bill was being contemplated and when it was passed, what we were talking about, what we meant. We probably should have spelled it out better, but we didn't. And so that's left to your interpretation. But I also wanted to express to you, as president of the National Court Reporters Association, how the National Association views these two states' tests. And to clarify one thing, I don't believe this is specifically, unless this is what the licensure board is asking, that anybody's necessarily asking for specific reciprocity for California and Texas. I believe there were individual people coming from those states looking to relocate to Tennessee that were questioning the reason why reciprocity wasn't being granted. But I would love to see, as a resident of Tennessee and a licensee of the state of Tennessee's Court Reporters Board, an establishment that the Texas test and the California test are equal to or superior to our test. So I appreciate, Mr. Chairman, you allowing me to address the board, and I will turn it back over. Thank you.
Thank you, Mr. Curry. That was very instructive. And you are correct in your statement that these were applicants that are coming to us as well. We've seen some of that across, across the board. So thank you. And just one further note too, I didn't really dive into Texas testing requirements, but they have to pass the certified shorthand reporter examination issued by their state. So that was the test that Mr. Curry was referring to. So they do have testing requirements. And it's up for the board to decide if they are substantially the same or more stringent requirements. If the answer is yes to that question, then we'll need a motion in that regard to enter in to begin drafting an agreement between Tennessee and those states. If the answer is no, of course, then that will cease the conversation. But something formative for discussion would be helpful and instructive.
Hey, Glenn, this is Ken Mansfield, and I got cut off for some reason. I've joined it just at the end of Mr. Curry's remarks. But I actually pursued this years ago when I was chair 1 year of the board with some surrounding states, and no one was interested in reciprocity with our license. It's my understanding that if we're going to have reciprocal agreements, those states have to accept our licensure as well as us accepting their licensure. It has to go both ways.
Yes, sir. That would be the goal.
And so, has Texas or California or either one requested reciprocity agreements with Tennessee at this point?
No, sir. Those are at this point it's applicants coming to us. So what we would do is begin drafting that language and then approaching them on that basis.
I thought we already had a provision for people who wanted to become residents of Tennessee or if they obtain a license, if they have passed a test that's equal to or greater than the RPR, they could apply for licensure on their own standing now.
That's correct, but no determination was made that Texas and California meets that standard. So that's what we're discussing here today. If the board determines that they do meet that standard, then of course we can move forward with the reciprocity agreement.
Well, would we call it reciprocity if they're not recognizing our licensure?
Well, that's the goal here isn't to necessarily have the debate, but just to move that forward, put that end game in mind. Our draft would include that provision that they would recognize ours.
Well, it would really be up to them as a matter of speaking then.
Well, if that was the basis of that reciprocity agreement, the denial, would at that point would cancel the reciprocity agreement.
Okay.
This is Marilyn Morgan. Is there no way we can acknowledge the Texas and California certifications some other way?
I think so.
Yeah,
If we do deem that since we're just talking, there's two different issues. If we're talking about the reciprocal agreement, then that agreement would be one that would be mutually beneficial, and then Mr. Mansfield and I were having that, of course, we're laying that out. However, the reciprocity path, if we deem their certificates to be substantially the same or more stringent, then we would accept that, without the reciprocity agreement. But we'd like to go one further with the reciprocity agreement if we could get some mutual consideration. So that ultimately we desire the reciprocity agreement. So that way it can be mutually beneficial to both licensees, and we'd like to pursue that if it would be the will of the commission or the board rather. But yes, ma'am, you're correct. We could, if we deem that their test to be as substantially equivalent or more stringent, then we could accept their licensees. But do we need that determination?
This is John Rambo. It seems like it would be beneficial to our court reporters to have the reciprocal agreement in case they were to relocate to Texas and California. It would make the process easier for them. So for that reason, I'll make the motion that we pursue a reciprocal agreement.
Thank you, sir. We have a motion then on the table. If there's further discussion, we can have that. But unless there's a second, we can move forward with at least pursuing that part of the discussion. And,
excuse me, this is Ken Mansfield again. When I was pursuing reciprocity with some surrounding states, specifically Missouri, they informed me that they would never have a reciprocal agreement with Tennessee because some of the licensees were grandfathered in without testing. And so that was an issue.
And there is grandfathering, but we can at least make the attempt and see if there's a desire or if there's a field for that, and that's really what we're after today. And we, of course, we'll all report the results of that. If we run into a closed door, then we'll report that back to the board as well. But we at least wanted the authority to at least make the attempt for the sake of both licensees.
This is Marilyn again. If we make the attempt, what can we do since we meet so, infrequently? What can we do in the meantime to accept the person?
Well, if we deem that that test is substantially the same or more stringent, then at that point, by reciprocity, we could accept them. But we'd like to go one step further and also pursue the agreement. So those are two separate issues, but they're somewhat similar. So I can understand the blending of the two. But yes, ma'am, we could accept them if the board deems them to be more substantially the same or more stringent. Which, if we approve the reciprocity agreement or a draft in that regard or the pursuit of that, then we would be making that claim. So that they would be fine. But we'd like to go beyond that for our licensees as well.
Okay, I understand.
Glenn, this is sorry, this is Brandon Pettis. I just want to make sure that I understand this. So basically, Judge Rambo's motion that is before the board right now is to determine whether Texas and California standards are more stringent or substantially similar to ours. And to Ken and Marilyn's points in terms of the minutia, like taking care of issues like with the grandfather clause, with some of those reporters who were grandfathered in, and whether there's actually going to be sort of mutual reciprocity to the benefit of all parties. That's something that could be ironed out later when there's some sort of proposal to amend the statute or whatever. Is that correct?
Yes, sir. You're definitely on the right track. We would of course accept it. I mean, if their requirements are essentially the same or more stringent, then we wouldn't block people from access to our to be a licensed court reporter into our state. We would welcome those folks like we would in any profession. But at the same time, too, while we're doing that, we'd like to go on further and pursue the reciprocity agreement, like you noted, and then just see where we go. And if they can give us a criteria for why or they wouldn't, then we can address that at that time.
Sure. Well, with that understanding, I would like to second Judge Rambo's motion.
Thank you, sir. We have a motion to pursue a reciprocity agreement with Texas and California. Judge Rambo, and we have a second from Mr. Pettis. For a roll call vote, Judge Rambo?
Yes.
Ms. Morgan?
Can I have one more little bit of discussion, please?
Yes, ma'am, please.
Okay. California will not even recognize an RPR or a merit rider. Merit riders are at 265 words a minute. I don't think that they will. I just want to make sure that we have an immediate fix because we have a shortage going on, and I know at least 2 California reporters who would like to apply for Tennessee, and they're not allowed to now since they have no RPR. But like I said, California doesn't recognize the RPR. Are we assured that we can do something now?
Yes, ma'am.
Okay.
Yes, ma'am.
Okay. In that case, I vote yes.
Right. Thank you, Ms. Morgan. Mr. Mansfield?
Yes.
Mr. Pettis?
Yes.
Ms. Neal?
Yes.
And Ms. Branham?
Yes.
Right, thank you very much. We will draft that up and approach both of those states. Of course, we'll begin accepting their reporters, and we'll ask that they do the same for ours. And if we run into some stop gaps there, we'll report that back to the board and give you the criteria for those that was relayed to us. But we won't borrow any trouble. We'll just see how that goes and send that on up and begin working on that. Thank you for the authority to do that. Moving on then to the legal report. I believe Dennis Gregory, are you there? We'll let you get started, I guess, and just introduce the legal report. We only have a couple cases.
Yeah, we only have the 2, and they're basically the same complaint, just involving 2 different people. Essentially, if the board has already sort of familiarized itself with the summaries, I can just what wait for your all's questions. If you don't have any questions, recommendation is to close both of the complaints based on really just a lack of evidence, and the complainant didn't provide our investigator with a whole lot of information, and really not even a way to get back in touch with them. I think the email address that our investigator had tried to communicate with them was bad. So they kind of speak for themselves.
Any comments on those and any questions about the legal report?
This is Ken Mansfield. I move that we accept the recommendation.
Okay. We'll go ahead and read both of the complaint numbers into the record then. Case number 1 is 202-00-12891. The recommendation is to close. Case number 2 is 202-001-2901. The recommendation is to close. Mr. Mansfield, your motion was to accept the council's recommendation. Do we have a second?
This is Marilyn Morgan. I second.
Ms. Morgan is second for roll call vote. Judge Rambo?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Pettis?
Yes.
Neal?
Yes.
Ms. Branham?
Yes.
Thank you. The legal report has passed. We'll get that taken care of then, which this gives us a great opportunity to discuss the agreed citation schedule. The problem we're running into is that our board, we meet twice a year. That's not necessarily a bad thing. It's just that because we want to make sure that we cover all of our business, and we typically we have enough in those 2 meetings to do that. So there's nothing wrong there. However, a lot of our complaints sometimes can fall outside that 180-day metric, and like these complaints, sometimes they can be very just straight up and down. So we found that with some of our other boards that an agreed citation schedule or a combination of that with administrating handling of some of those complaints would be in order and have been helpful. We've those complaints that we see a lot of that that we can identify as falling in up a certain category, then we can go to our schedule and respond accordingly, and then if once the board grants us authority to do that, and then close those out. It's just like basically a ticket on the side of the road. If you're going 40 and a 30, you get pulled over, they can write you a ticket. Now you can go to your court date, which would be in this case the complaint report, or eventually a formal hearing, or you can just pay the ticket and then have that closed out. That's kind of what we'd like to do here. Those standard sort of items that the board would be comfortable with delegating that authority. We basically have a schedule that we go to, whether it be a letter of warning or a fee, or a $250 or $500 fee. And then we issue that agreed citation by the authority of the board. And then they, if they agree to that, then they make that payment. It goes into their record, and then we close that complaint out, and it doesn't have to come before the board. And then it's not waiting on the next meeting, which in this case would be September. So for example, if we have somebody that we had a complaint come in maybe last week or a month ago, and we're still working that complaint, that one would have to wait till September before we took care of that. So if we had an agreed citation schedule as a place to put some of those complaints and process some of those, we find that, and Cosmo Barber has done that and saved quite a bit of money on legal expenses as well. The other one that we've done that is Collection Service Board, and had some good benefit there. So if that's something that the board would like to entertain, we won't be voting on this today, but we just want to have the discussion about the agreed citation schedule in front of you, if that is something that you would be happy with. And do you want it broken up by categories, or just a straight up and down first, second, third offense, and that's it? Hugh, did you have any comments that you'd like to add or pipe in?
Hi, this is Hugh. I think you covered everything, Glenn. The only thing I wanted to reiterate is that I drafted these citation schedules in 2 different versions here, just by way of trying to get commentary and discussion. So we're not going to be taking a vote on this today, but I'm going to sit back and listen to and take notes on the discussion and hopefully get, if you want to move forward with the agreed citation schedule, then my main goal or hope is that we get plenty of discussion on these today so that I can have enough moving forward to present to the board at the next board meeting.
Okay, great. All right. Well then, members, if you've noticed that the first page is pretty much the same. There's not a whole lot going on there except for laying out what it is that we're trying to accomplish. The meat of what we're trying to accomplish will be on page 2 of both schedules. You have, if you look at document 5 and then 5A, you have one that's the agreed citation guidelines, and then the other one is the guidelines with categories. So let's just look at the 5. It's the guidelines. You have a first offense, second offense, third offense, refer to legal. And that legal could be perhaps, more punitive sort of measures. The things that fall into those offenses would be unlicensed practice of court reporting, no license ever issued, license previously issued, currently expired, suspended, or revoked. So maybe there's a gap in their license, or they've just never been licensed. They knowingly present or file false information to obtain a license. That could be a possibility. First offense would be 250, second 500. Third one could be refer to legal for more punitive or even a formal hearing. Let's see, the second one would be failure to obtain a minimum of 2 continuing education credits over a 2-year period in courses approved by the board. So, they did the renewal and then failed to complete their continuing education credits. So those are the 2 primary things that stand out for the reasons that things would be referred to the board. So that's the schedule, or we could go to the category where if there's no license ever issued, then we create that's a category 1, and then that is a warning letter, the first offense. That's really the only difference, is that if there was never a license issued, we give those folks a warning letter, a letter of warning, just to let them know that, hey, you have to be licensed to do what you're doing. So I guess that's really the debate. Is there one that
And
we're feeling?
John Rambo, if I could ask you a question, and if you don't have a license, let's say you do a job and that's one incident and you get reported for that, and then a week later you do another one, and let's say you do 3 or 4 within a month and before it comes to your attention, do you group that as one as a warning, or are you signing for every one of those? What's the plan in that regard?
Yeah, we've had some discussion about, that's a great question, because we've had that same discussion in Collection Service Board as well. And it would just be what was reported. So it'd be one incident of reporting. But again, there could be some address in that regard. If the board wants to say any moment or action of unlicensed activity is a first offense, really, because you can find that way, obviously. So if that's the instructions, then we could treat it that way. Anything, if they've got more than one on record that we're aware of, then we just automatically refer it on the legal report. If that's what the board wants to do, we can do that. Or if there's a certain period of reporting, if they certainly give some instruction to legal in that regard as well. So it's really up to the board how they want to pursue that.
This is Hugh again, just to jump in on this. These, the first offense, second offense, and third offense, these are solely recommendations. They can be changed. So if you do not want to issue a warning letter at all, you don't have to. So I just wanted to say that, but everything can be debated here.
Judge Rambo, what would be your sense of what would be considered a first offense?
To me, the first offense is the first time you get a warning, and if you do it again, or citation, and you do it again after that, would constitute the second offense. I wouldn't come down and issue 3 citations if they did 3 before they got the first warning, unless it's just something really egregious going on, and then you can either, I'm assuming you'd have the authority to skip the citation and just go directly to the board.
Yes, sir.
If you felt like you had a problem.
Yes, sir. Yeah, this is just opportunities to clear those cases, but if they found something egregious, it wouldn't be, we're not held to this by statute, you know. It would be one of those situations we could, Dennis Gregory could, of course, make a recommendation to the board and bring that straight to the board. Would the board feel like is there a consensus among the board that to Judge Rambo's comments that basically when they were first put on notice, when their first contact with our board would be the first offense, unless of course something egregious. The egregious meaning they've been doing maybe for working over over a year taking reports or something. And this, of course, if you have anything you want to add to that, that's based on your experience, then of course we welcome those comments.
Well, this is Ken Mansfield, and I think that when the offense first comes in, maybe we should ask them to self-report how many times they've done this. Without
Great idea.
Hello?
Yes, sir. Is there any other comments? And I thought Dennis was trying to break in.
Oh no, I was going to say that that's a good idea in terms of, I think it's a reasonable way to approach the first offense would be the first time that they've been reported as having engaged in unlicensed reporting, and then after that, of course, it would be treated differently. And with regard to what Mr. Mansfield said about the self-reporting, we always ask, I mean, at least in the other boards, I know if someone applies for a license, one of the questions posed is how many times or have they engaged in any unlicensed, fill in the blank for the, based on the profession. So that's not a bad idea either.
And is there a certain mark or threshold that we're talking here that we would say we'd want to see that automatically referred to the board, Mr. Mansfield? Did you have something in mind?
I would think 3 times would automatically advance it to the board.
Is there any other comments in that regard from our other members?
Three times. This is Marilyn. 3 times is a good suggestion.
Okay. If that's the will of the board, then we could say first contact with us is first offense. And then Dennis, if you could just keep in mind, and Hugh as well, that if there's more than 3 incidences of self-reported instances of unlicensed activity, then it would just automatically be referred to the complaint report. Does that sound about right?
This is Marilyn. I'm sorry. Go ahead.
Ms. Morgan, you're up.
I was just wasn't sure if you were looking for an answer, but I think I understand the issue, and that's 3 times seems to be the number of violations. If 3 violations are committed, then the board would like to review the complaint.
Right.
Sure.
This is Ken Mansfield again too, and another thing I would suggest is, although we have to meet 2 times a year by statute, we can meet more often than that if necessary.
Yes, sir. That's correct.
This is Marilyn. I would like to meet more often than that. It seems like it's from one year to the next before we're, really resolving anything. But that's just my opinion.
Now we can also we can of course meet telephonically. We've done that before as situations require. One thing we wanted to avoid was meeting just for the complaint report when we only have maybe 2, sometimes 3 complaints tops, sometimes just 1. We didn't want to have folks driving and trying to schedule that for that purpose. Certainly, if the things we're not limited, but we always put 2 on the schedule to make sure that we have that locked. But we can always meet more. That's fine. But for sake of the legal report, we don't have a precedent for meeting just for a couple cases. Typically, we take care of those or wait till the next meeting. But with the citation schedule, I think we would do well to be able to cover those without forcing ourselves into a meeting for 1 or 2 cases solely. Okay, so I think we've established the offenses. Do we like the citation that scheduled just with no categories, or do we like the ones with the categories?
This is Stephanie Branham. I personally like the ones with categories.
Okay.
It makes sense to me reading it.
I think so too. The warning letter seems to be helpful, especially with those folks that aren't licensed reporters. It gives them an opportunity to understand that what they're doing is unlicensed activity and requires some sort of response from them.
Hey, Glenn, sorry, can I interrupt? Mr. Mansfield, can you put yourself on mute when you're not speaking? We're getting a lot of distortion from you.
Yeah, I saw that mighty good. Trying to get it.
There we go. Thank you, Dustin. Appreciate that. Okay. Do we have any other comments about the categories versus the guidelines? Do we like the categories, or do we like the just general guidelines? They're pretty much the same. The only difference is that the categories separate out unlicensed practice of court reporting where a license was never issued, and that gives the first offense a warning letter. That's really the difference there.
This is Marilyn. I like the categories too.
Okay, great. Any other comments?
Ken Mansfield here, and I like the categories also.
Okay. All right. Hugh will sort of tighten that up then and get that the ones with the categories back to us. Hugh, did you have any other comments or questions that you need from the board as far as direction in that regard?
No, I do not. Not that I can think of at the moment. So no, I'm good.
Okay, great. And of course, if we run into anything that we need more, I guess, input from the board, I'll of course send out a request in that regard, blind copying everyone, of course, so as not to be in violation of being a sunshine statute. So other than that, I think we've accomplished all of our business. And does any of the members have any new business that they would like to discuss? Or
This is Marilyn Morgan. I'm sorry. I've got kind of some new business, old business. I've been approached by several reporters again about having a photo ID card. That the paper that everybody's given is just disintegrating over time, and the courts require us to produce that when we go in. So I'm just bringing that up again to see if there's anything we can do about it.
Glenn, I took myself off mute. If it's okay for me to answer, since we've asked for this before. Thank you. And this is Roxana Gamusio. I so appreciate Marilyn, your question. It's been presented before. We are more than happy to bring it up again and treat the program as a unique need that is very relevant to this industry, and so we will definitely do that. The push is in the opposite direction. More of the programs are actually not printing those documents, especially, of course, during these times. But even once we get back to a new normal, individuals can print their own. So that won't be any different for court reporters. If the version that you receive in the mail gets like you said, just tears up, you use it so much, you can log into our system and actually print it. There's no cost for a duplicate, and you can do that. But we will proceed once more with asking if the photo could be added and any exception be made. The last time that I personally presented that, it was not approved. It's just not a statutory requirement, and we're moving away from those printed items. And so that was the reason at that time. But we will definitely do it again and give you some feedback on what else or where administration is with that and what the reason for it is.
Okay. And one thing I do remember, Miss Morgan, we had that conversation back in March 2018. If you wanted to review, it's under the director's report, page 2 of March 2018. And at the time, of course, well, like Miss Director Gramusio did inform, we'll take that back up at the flagpole. However, at the time, the board acknowledged that they did want those cards, and I remember, I believe we voted on it as well to that regard. Yes, that's correct. Yep. At the time, yes, the statement was this that we voted on. If financially feasible, in regards to manpower, equipment, and time, the benefit of having a court reporter photo identification card is important, and it is the board's position that if that criteria is met, then the photo ID cards should be issued. Judge Rambo motioned to adopt that statement. That was seconded by Mr. Mansfield, and the motion passed. So as far as the board is concerned, we've done all of the action required from us to move that forward and express interest in pursuing that. It was decided by executive management at the time, of course, that was 2 years ago, not to pursue the issuance of photo ID cards with licensing information. So I will take it back up the flagpole and see if that position has changed, but there won't be any further action required from the board on that issue. But thank you for bringing that up.
Thank you.
Yes, ma'am. Is there anything else? Okay. Then we'll entertain a motion to adjourn. Do we have such a motion?
I make a motion to adjourn. Ken Mansfield.
Ken Mansfield makes a motion to adjourn. Do we have a second?
John Rambo, second.
Thank you, sir. Judge Rambo, a second for roll call vote. Judge Rambo?
Yes.
Thank you. Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Pettis?
Yes.
Ms. Neal?
Yes.
Ms. Branham?
Yes.
Thank you. We are adjourned. Thank you so much for everyone that's come out and made this possible today and making the adjustments during this difficult time. And we look forward to seeing you guys again soon. And if you have any questions, you know where to reach us.
Thank you.
Thank you.
Thank you.